Hi cadets! Upon the request of some criminology graduates who are on their phase of preparation for the incoming criminology licensure examination, I decided to upload some videos. These videos will revolve its discussions on topics that will come out in the board exam. Because topics are quite lengthy, what I did was synthesize and chunk topics according to episodes. So in this episode, we will be reviewing half of the topics under non-institutional correction, while on the other hand, the remaining topics of the subject will be reviewed under episode 2. Take note, non-institutional correction subject is one of the subjects under the major area correction, and correction is 10% in the criminology licensure examination. So to start with, let us define first what is correction. Correction is the branch of the administration of the criminal justice system charged with the responsibility for the custody, supervision, and rehabilitation of convicted offenders. Remember that we have 5 pillars of the criminal justice system. In chronological order, we have first the law enforcement, second is prosecution, third is court, fourth is correction, and the last one is community. Unlike other countries, our jail and prison administration and control in the Philippines has a fragmented organizational setup. Because in the Philippines, even though the agency has the same responsibility in terms of control and rehabilitation of offenders, sometimes this kind of agency is supervised by a different agency of the government. Like say for example, Bucor is under the Department of Justice. BGMP, on the other hand, which has the same task in the government, is under the DILG. So meaning they have a different supervisory agency, but they have the same responsibility. That responsibility is about the rehabilitation and control of offenders. On the other hand, Bucor, when under the DOJ, has supervision over national penitentiary and its penal farms, while BGMP, which is under the DILG, has control over all city, municipal, and district jails nationwide. So if we go along, like provincial jails, on the other hand, is supervised by the provincial government. Youth Rehabilitation Center, on the other hand, is supervised by the DSWD. But then again, the responsibility of these agencies are the same. And that responsibility or that task is about the control and the rehabilitation of offenders. On the other hand, PPA stands for Parole and Probation Administration, which is headed by a probation administrator and assisted by the assistant probation administrator, is also under the Department of Justice, same as the Board of Pardons and Parole. On the other hand, lock-up jails, which is made adjacent to the Philippine National Police Agency office, is under the PNP. So we have 5 justifications of punishment. 1 is deterrence, 2 is rehabilitation, 3rd is restitution, 4th is retribution, and the last one is incapacitation. Deterrence is about frightening an individual defendant with punishment. Or to simply say, deterrence is about discouraging the public or the specific individual from committing a criminal act. While rehabilitation, on the other hand, prevents crime by altering a defendant's behavior. So the behavior of the criminal or the behavior of the convicted person will be shifted from being a law violator into a law-abiding citizen of the country. Restitution, on the other hand, is about remunerating or giving, providing money paid or services provided to victims, their survivors, or to the community by a convicted offender to make up for the injury being inflicted to the victim. Retribution prevents crime by giving victims or society a feeling of avengement or revenge. On the other hand, incapacitation is about removing a defendant from the society, or simply say, you protect the society by isolating the convicted individual inside jail or prison. Basically, the difference between the two is that in institutional-based approach, the person has been convicted of a crime
will have to go to jail or prison and will serve his years of sentence. The rehabilitation will take place inside that jail or prison. On the other hand, in non-institutional correction or community-based approach, once a person has been found guilty beyond reasonable doubt by a competent court, instead of transporting the person to jail or prison, that individual will have to be rehabilitated within the community subject to supervision of the authorities. So let us go first to the definition of probation. Probation comes from the Latin word probatio, which means testing, and probare, which means to prove. Legally speaking, under Presidential Decree 968, probation is defined as a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the supervision of a probation officer. So meaning, probation is a partial extinction of criminal liability. I say partial extinction of criminal liability because probation, once given to the person, is coupled with conditions, and these conditions are imposed by the court. So to understand the genesis of probation, let us review its historical development. We will start with Matthew Davenport Hill. Matthew Davenport Hill is considered as the father of probation in England. He was in the forefront of reforming juvenile offenders. He finds persons who act as guardians of the juvenile offender. He conducted his experiment in the Birmingham court, and beginning in the early year of 1421, he acted for and in behalf of juvenile offenders because he believed that number one, the individual is not fully corrupt. Number two, there was reasonable hope of reformation. And number three, where there could be found persons to act. In the United States, the first state to enact a real probation law was Massachusetts. It was only in March 4, 1925 that the United States Federal Probation Act was enacted. But behind this development, it was actually John Augustus, who was known as the father of probation, who made influence in the enactment of different laws related to probation in the United States of America. Now let us go to the background of John Augustus, who influenced on the development of probation in the U.S. John Augustus was a shoemaker. He was born in Woburn, Massachusetts in 1725, and in 1827 he moved to Boston and set up a shop at Franklin Avenue near a courthouse. He began to visit courthouse because of his membership with the Washington Total Abstinence Society. This is an organization which reclaims persons being charged with drunkenness. During the first year, he took only men charged with drunkenness, then men and women charged with other offense, and then later on children. The methods of Augustus was to provide bail for temporary suspension of punishment of sentence, and then he sought counsel and assist his charges in finding homes, securing employment, and adjusting family difficulties of a person charged with drunkenness. And then later on, at the end of the probation, he brought the offender back to the court, and if no further charges are found, judge imposes a nominal fine with cost if man is poor. And Augustus would advance fine as a loan. So basically, the method of Augustus was to pay the fine on behalf of the person being charged with drunkenness, and that payment will serve as a loan. So technically, since it is a matter of a loan, the person who has been charged with drunkenness will have to pay Augustus of the amount being paid to the court. In the Philippines, the first law which offered probation to these persons being convicted of a crime was Act number 4221 in 1935. But this law was considered as unconstitutional by the Supreme Court. This was decided under the People of the Philippines versus Vera in 1937. This law was declared unconstitutional because of one fatal provision. And that fatal provision can be found in Section 11 of Act number 4221. Section 11 states that this act shall apply only in those provinces in which the respective provincial boards have provided for the salary of a probation officer. So basically, this section discriminates the economic background of a particular province, because only those provinces, as required by this law, only those provinces who can pay for the salary of the probation officer be qualified to offer probation. So basically, because of this discriminatory provision of Act number 4221, the Supreme Court declared it as unconstitutional. Presidential Decree 968 was signed into law by President Ferdinand Marcos on July 24, 1976. But take note, it was only in January 3, 1978, where the provisions of PD 968 took effect. So the difference between 4221 and 968 is that in 4221, it discriminates on provinces which cannot afford on the salary of the probation officers. While in PD 968, the new law on provisions applies to all provinces and cities uniformly and without discrimination. The salary of the probation officer in each province or city is provided for by law, no longer subject to the discretion of the respective provincial boards. So, before we go deeper to probation, let us first find out the definition of these terms. First is absconding petitioner. Absconding petitioner is defined as a convicted accused whose application for probation has been given due course by the court but fails to report to the Parole and Probation Office or cannot be located within reasonable period of time. So again, an absconding petitioner is a convicted person whose application for probation has been processed by the court, but then again, that person fails to report to the Parole and Probation Office on a specified time. So that person shall be classified as absconding petitioner. On the other hand, absconding probationer is defined as an accused whose probation was been granted but failed to report for supervision within the period ordered by the court, or a probationer who fails to continue reporting for supervision and or whose whereabouts are unknown for a reasonable period of time. So basically, the difference between absconding petitioner and absconding probationer is on the approval of the application for probation. For absconding petitioner, the process or the stage is still on the application for probation, and the person fails to present himself to the Parole and Probation Office. On the other hand, absconding probationer is that it entails that the probation or the application for probation has already been granted. But unfortunately, after the granting of the probation, the person fails to present himself or fails to report for supervision to the probation officer. Next is petition. Petition means application for probation, or when you apply for probation. Petitioner is a convicted defendant who files an application for probation, and if a person has already been granted with probation, he shall be labeled as probationer. Next is probation investigation. This is the process of selection, diagnosis, and planning with the client. Next is probation supervision. Probation supervision is the continuous process of helping the client to follow through with the plans, re-evaluation, and working with the client in the process of planning his life to meet dynamic situation. Next is probation officer. Probation officer is a public officer who investigates for the trial court, a referral for probation, or supervises a probationer. Probation order, on the other hand, is an order of the trial court granting probation. The agency which supervises on the granting of probation is known as the Parole and Probation Administration, or in Filipino, Pangasiwaan ng Parole at Probasyon. Its abbreviation is PPA. The PPA is headed by a probation administrator, assisted by an assistant probation administrator. the administration is appointed by no less than the president. Who are qualified to probation? These are the qualifications. Number one is any first-time convicted offender, but we'll be dealing with the exceptions on the next slide. Next is 18 years of age and above, not otherwise disqualified under PD 968. As a general rule, probation applies to all sentenced or convicted offenders, all first-time offenders convicted of crimes punished by imprisonment of not more than 6 years. So what is required by the law under the general rule is that the number of years of sentence of the person being convicted shall not exceed 6 years for him to be qualified for the application for probation. On the other hand, these are the disqualifications of probation. Those sentenced to serve a maximum term of imprisonment of more than 6 years, this is what I was saying a while ago, that if the person's year of imprisonment exceeds 6 years, let's say 6 years and 1 day or 7 years, that years of sentence will disqualify him to apply for probation. But take note, cadets, the 6 years maximum refers to the sentence actually imposed, and not the prescribed by a law for the offense committed. So what I mean by this is that if in case, let us say the person committed a particular offense and the number of years of sentence to be imposed, supposedly to be imposed by that person as stated by the criminal law, let us say is 12 years, but then again, in consideration with the mitigating circumstances, that 12 years becomes, let us say, 5 years, what will be given cognizance or recognition shall not the 12 years, but rather the 5 years as originally imposed by the court as a punishment to the person being convicted of a crime. So again, if a particular offense is supposedly be punishable by 12 years under the criminal law, but then again, in consideration of the mitigating circumstances, let's say mitigating circumstances, these are circumstances that will lower the number of years of imprisonment. So in consideration with the mitigating circumstances, if that 12 years supposedly be given to the person was reduced into 5 years, so what we are going to give recognizance or what we are going to give consideration is not the 12 years, but rather the 5 years. In that case, the person will be qualified to apply for probation simply because the number of years or the sentence actually imposed is 5 years. Next disqualification is those convicted of subversion or any crime against the national security or public order. Like say, for example, we have treason, rebellion, sedition, kudeta. There's a list of crimes against, again, the revised penal code is arranged or clustered into titles. So you can actually see the different crimes against national security and public order under the criminal law. So if you want to have the full list of crimes considered under the title Crimes Against National Security and Public Order, you can actually download Criminal Law Book 2. Other qualification is those who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day and or a fine of not less than 200 pesos. So this is the exception that I told you a while ago. If we will go back to the previous slide, the first qualification of the probation is in a first-time convicted offender only. But then again, there is an exception. A person being convicted of a second crime can be qualified for probation if in case his imprisonment is less than 1 month and 1 day, or a fine, his punishment in terms of fine is less than 200 pesos. So to fully understand the exception under the qualification is that if you will take a look on this slide, let us say previous conviction if 1 month qualified for probation. But if 1 month and 1 day or more disqualified or probation. So let's say, for example, if a person has been convicted of a crime and his punishment, let us say, is 2 months, the next time he committed a crime, he will no longer be qualified for probation simply because his previous conviction is 2 months, and that exceeds from 1 month. On the other hand, if in case the first crime or the punishment of the first crime was punishable by, let us say 25 days or 20 days only, or say maximum of 1 month only, when that person will commit another crime, that person will still qualify for probation simply because the previous conviction was punishable only by 1 month. In terms of fine, if less than 200 pesos, the person will still be qualified for probation. But then again, if 200 pesos or more, that person will be disqualified for probation. The fine that is stated in this slide refers to the previous conviction of the individual. Again, in terms of imprisonment, if the previous conviction is 1 month, the person will be qualified for probation, 1 month or less. But if 1 month and 1 day or more, in terms of the previous conviction, the person will be disqualified for probation. In terms of payment again, if less than 200 pesos from the previous conviction, the person will be qualified for probation. But 200 pesos or more, that individual will be disqualified for probation. Now take note, probation is not a right, but a privilege, okay? It is only a privilege granted to the person who applies for that probation, and is the only agency that will grant it is no other than the court. An offender can be granted probation once only, okay? That is the rule of thumb. Probation can be granted once in your lifetime. Under Presidential Decree number 1990, an order granting or denying probation shall not be appealable. So meaning, if in case the application for probation is denied by the court where the person applied that probation, you cannot make an appeal, or you cannot exercise your right to appeal to a higher court, because what the subject matter or the issue that is involved is probation. Okay, so the granting or the denying of probation shall not be appealable to a higher court. Also, under Presidential Decree number 1990, no application for probation shall be entertained or granted if the defendant has perfected an appeal from judgment of conviction. The filing of the application shall be deemed a waiver of the right to appeal. So basically, if the person has been convicted of a crime and he will apply for probation, you cannot actually apply for appeal and apply for probation at the same time. It has to be one only. If you will apply, or you already perfected your application for appeal to a higher court, that will deny you from having or from obtaining probation. So it has to be one among the two. It's either you apply for appeal and you do not apply for probation, or you rather apply for probation but you waive your right to appeal. Under PD 968, the court will not grant probation if after investigation conducted by the probation officer, it finds that the offender can be treated better in an institution or other places for correction, or the offender is a risk to the community, or the probation will depreciate the gravity of the offense. What is the effect of filing an application for probation? The court may, upon receipt of the application, suspend the execution of sentence imposed in the judgment. Take note, the word that is used here is suspension or suspend. So meaning, Since the execution of sentence is only suspended once the person will violate the conditions by the court or the conditions of the court, the person may be arrested, will be arrested and will be brought back to prison and will serve the original sentence. Take note again, the word that is used here is suspension of the execution of sentence imposed by the judgment. So the question is, where and when to file the petition for probation? A petition for probation shall be filed by the applicant for probation or the petitioner with the courts that tried and sentenced the offender at any time before the imprisonment starts. So there are two aspects that we have to consider. One, it is the court that tried and sentenced the offender which has the sole authority to grant probation. The granting of probation shall be done before the imprisonment starts. So basically, if the person has already been imprisoned inside jail or inside a penal institution, the imprisonment or the serving of the imprisonment deprives or will disqualify him from applying probation. As to when, again, any time before the offender starts serving his sentence, but within period for perfecting an appeal or 15 days from the promulgation or notice of the judgment of conviction. So meaning, the petitioner or the convicted individual will only be given 15 days to apply for probation. But if an appeal has already been perfected after 15 days, that means the person will be disqualified for probation. As I have said a while ago, it's either you apply for probation or you apply for an appeal. If you want to apply for probation, you make sure that you waive your right to appeal, because applying for probation means you already or you waive your right to appeal the case on a higher court. But we have an exception. Under Section 42 of RA 9344, the Juvenile Justice and Welfare Act of 2006, the court may, after it shall have sentenced a child in conflict with the law, and upon application at any time, place the child on probation in lieu of service of his sentence. So RA 9344 is actually an exemption from PD 968, because in PD 968, the giving of probation or the application for probation shall be done within 15 days from the promulgation of judgment. But in RA 9344, it does not specify number of days, but rather the application of probation shall be done any time, and probation shall be given in lieu of service of the sentence of the child in conflict with the law. What you can see on your screen are actually step-by-step process on the application for probation. So the first step is that the offender or his counsel will file the petition for probation within 15 days from the promulgation of judgment. So after the file for petition for probation, the court will determine the qualifications of the convict, and then the court will notify the prosecutor. After that, once the notification is received by the prosecutor, on the other hand, will submit his comments within 10 days. And if upon scrutiny, the petitioner is qualified for probation, his application will be referred to the probation officer or probation office for PSI or post-sentence investigation. The probation office will be the one to assign to a particular probation officer for the conduct of the PSI. The PSI will have to be conducted within 60 days, because within that duration, the PSIR will be submitted to the court. So the probation officer who conducts the post-sentence investigation will make a report. We call that one as PSIR, and the PSIR will be the PSIR will have to be submitted to the court who ordered for the conduct of the PSI. So while investigation and resolution is ongoing, the accused will be temporarily released in two modalities. One is he can be released through bail, and if bail is not available, he can be released through recognizance. When I say released through recognizance, meaning the person will be released to a person of good reputation in the community. Usually, release of recognizance, or the persons who will have the release of recognizance will be this public officials in the municipality, barangays, or the cities. The last step would be the court grants or denies the petition for probation within 15 days upon receipt of the PSIR. So once the post-sentence investigation report has already been submitted to the court will decide whether to grant or to deny the petition for probation. If the court grants the probation, then that means the convicted individual will spend his rehabilitation inside the community. But if the court will deny the petition for probation, that means the convicted person will have to be delivered to the prison or jail. What is post-sentence investigation? It refers to the investigation conducted by a probation officer to obtain information regarding petitioner's character, antecedents, environment, mental and physical condition with the aim of determining whether the latter is qualified and suitable for release under probation. So if we will go back to the previous slide, there is a step there in the process of the application for probation that requires the conduct of the PSI, or the post-sentence investigation. So again, if the court will order the probation office to conduct PSI, the probation office will have to assign one probation officer to conduct the post-sentence investigation. So it is the job of the probation officer being assigned to conduct PSI to inquire on the whereabouts, on the profile, the character of the convict, and to make some necessary recommendations as to whether that convict will be qualified or will be suitable to be granted with the so-called probation. PSI also has a step-by-step process. First is preliminary procedure. The probation office, upon receipt of the order from the court, shall assign a probation officer to conduct the PSI. This is the step that I mentioned a while ago. Then after PSI is already assigned to a particular probation officer, the next is initial interview. So within 5 working days from receipt of the court order, the probation officer assigned shall interview the petitioner. Next is investigation. Investigation is on the antecedents, mental and physical condition, character, and socioeconomic status of the petitioner. For collateral information, the relative shall be interviewed. When I say collateral information, these are information these are informations that can be collected by interviewing those persons, those individuals who actually know the whereabouts of the convict. The last step is issuance of post-sentence investigation report, or PSIR. So again, this shall be done within 60 days, within the duration of 60 days. So upon the completion of the post-sentence investigation, the probation officer shall submit a post-sentence investigation report to the trial court within the prescribed period of time. Is the petitioner had the right to counsel during the post-sentence investigation and covered by Republic Act number 7438? If you can still remember, guys, Republic Act number 7438 talks about the rights of the accused under custodial investigation. We have the right to remain silent, the right to speedy trial, the right to counsel, the right to be informed of the nature and cause of accusation, and many more. There are many rights. These rights are actually those rights of the accused. But then again, under PD 968, it is stated that during the post-sentence investigation, petitioner had no right to counsel. So meaning, during the PSI, during the conduct of the PSI, the convict has no prerogative, has no right to avail on the services of the lawyer. Further, petitioner as well is not covered by Republic Act number 7438, providing right of the accused during custodial investigation. So again, the rights of the accused are not covered during the post-sentence investigation by the probation officer. Absconding applicant. If the applicant whose application for probation has been given due course by the proper court but fail to present himself or herself to the proper office within 72 hours, this is 3 days, from his or her receipt of the probation order, said office shall first exert best diligent efforts to inquire on, search, find, and locate his or her whereabouts before it shall report such fact with appropriate recommendation to the proper court. Absconding applicant and absconding petitioner are two the same terms. Okay? Again, absconding applicant and absconding petitioner are two the same terms. These terms is actually defined. These terms means that a particular applicant applied for probation and the court processed the application for probation, but unfortunately, that applicant or the petitioner failed to present himself within 72 hours, okay, within 3 days, because it is actually within 3 days that the applicant will have to be interviewed. So if in case in that 3 days given by the duration given by the court, the petitioner fails to present himself, he will be considered as an absconding petitioner or absconding applicant. But then again, it is the responsibility of the probation office to find out, to inquire on the location or the whereabouts of the convict, and then again, after inquiring on the whereabouts or the location of the convict, the probation office will have to make appropriate recommendation to the court. Can the offender be released while his application for probation is pending? Yes, this is actually what I have discussed a while ago. There are two modalities for the release of the convicted person while the PSI or while the resolution for the granting of probation is still on the process. Number one is bail, or number two is release of recognizance. So if in case bail is not available, the person being convicted of the crime can be released through recognizance. And again, release of recognizance meaning the person will be in charge to the custody of a responsible member of the community. It's actually usually in the Philippines, it's actually the public officials that are used to be the point person in the release of recognizance. It's either barangay captain, barangay councilors, mayors, councilors, or any public officials. The grant of petition. Once probation is granted, the execution of the sentence will be suspended. Okay? Again, once probation is granted, the execution of sentence will be suspended. Take note again of the word of suspension, because probation is not the execution of judgment, but rather it is merely a suspension of judgment. I say suspension again because once the person violates any of the conditions of probation, the person can be arrested again and will be brought to the prison or the jail for imprisonment. And there he will serve his years of sentence inside prison or jail. The court, if grants the petition, will issue the appropriate probation order, and the petitioner will be released to the community, subject, however, to the terms and conditions imposed by the court, with the supervision of the probation officer. So it's actually the probation officer who will be supervising the whole duration of the rehabilitation of the convicted person who has been granted with probation. What will happen if the application for probation is denied? The offender will be sent by the sentencing court to prison to serve his sentence. But let us not forget that the law does not oblige the defendant to accept the probation granted by the court. He should indeed be allowed to turn down the same grant, especially since he might feel that the term and conditions thereof are too onerous for him. But let us not forget that the law does not oblige the defendant to accept the probation granted by the court. He should indeed be allowed to turn down the same. But let us not forget that the law does not oblige the defendant to accept the probation granted by the court. He should indeed be allowed to turn down the same grant, especially since he might feel that the terms and conditions thereof are too onerous for him. So basically, as for the information of everybody, it is actually the convicted person who applies for probation and whose probation has already been granted by the court has actually the right to refuse the grant of probation. And if in case the defendant reject the grant of probation, so what will happen is it's either the court will modify the conditions upon negotiations, or if in case upon negotiations the defendant still reject the grant of probation, then the defendant or the convicted individual will have to spend his rehabilitation inside jail or prison. The period of probation. If the convict is sentenced to a period of imprisonment of not more than 1 year, the period of probation shall not exceed 2 years. In all cases, if he is sentenced to more than 1 year, said period shall not exceed 6 years. So again, if the convict is sentenced to a term not more than 1 year of imprisonment, the period of probation shall not exceed 2 years. If more than 1 year, the period of probation shall not exceed 6 years. When the sentence imposes a fine only, and the offender is made to serve subsidiary imprisonment in case of insolvency, the period of probation shall not be less than nor twice the total number of days of subsidiary imprisonment as computed at the rate established by the revised penal code under Article 39. What are the duties of the probationer? When I say probationer, I'm referring to the person whose application for probation has been granted, or a person under probation. The probationer must present himself to his probation officer within 72 hours, report to his probation officer in charge of his supervision at least once a month, not to commit any offense, comply with any other conditions imposed by the court, and many more and other conditions set by the court. So these are a few of the conditions actually that have to be followed by the condition by the probationer. Other discretionary or other conditions are also the following: cooperate with the program supervisor, meet his family responsibilities, devote himself to a specific employment, comply with the program of payment of civil liability, pursue a prescribed secular study or vocational training, attend or reside in a facility established for instruction or reaction of persons in probation, refrain from visiting house of ill repute. When I say house of ill repute, I am referring to gambling, gambling den, bar, disco bar, and other house of ill reputes. Abstain from drinking intoxicating beverages to excess. What happens to a probationer if conditions or provisions are violated? So there are two things that will happen. The court may modify or the court may revoke the provision. So if the violation is serious, the court may order the probationer to serve his prison sentence. The probationer may also be arrested and criminally prosecuted if the violation is a criminal offense. So in the case of modifications, so the conditions will have to be, it's either be trimmed down or will be modified to a less or higher to a higher level. But if in case probation has been revoked or there is revocation of the granting of probation, that means the probationer will be prosecuted for the commission of a crime if it is a crime, or if in case if it is merely a violation of the conditions and the court revoked the probation granted to the convicted person, that person will have to be arrested and will be brought back to jail or prison and will serve his rehabilitation there at prison or jail. The modes and grounds of termination of the probation supervision. One is the successful completion of the program of probation. Number two, revocation for cause or death of the probationer. So, probation supervision can. When I say probation supervision, that's the duration where the person is under the supervision of the probation officer. It can only be terminated once again completion of the program, or number two, the death of the probationer. So those are half of the topics under non-institutional correction subject. If in case you do not understand something in any of the slides that I presented a while ago, I would really be happy if you type a comment or your reactions or your queries and questions under the comment section so that I could also provide my answers. For the remaining topics under non-institutional correction subject, it will be discussed under episode 2. So I hope you will subscribe to my channel, and I hope I was able to give additional learning to you cadets in terms of probation and other preliminary topics under non-institutional correction. Thank you so much for watching.